Welcome to the SA Mining Desk, your essential partner in understanding South Africa's mining sector. We're a platform dedicated to simplifying the intricate world of mining, from government regulations and groundbreaking judgments to essential industry reports. We deliver clear, concise information to equip you for every step of your mining journey. Join your host, he unpacks the mining sector for us.
Hi everyone, and welcome to the SA Mining Desk, your partner in navigating the South African mining sector. Thank you for joining us today. Today on Case Files feature of the SA Mining Desk, we're looking into a high-stakes legal battle over a gold-bearing tailing stump worth 435 million rands, situated on the farm Camelot 320JU in Mpumalanga. The Department of Agriculture, Rural Development, Land and Environmental Affairs, which we'll call Rural Development, is the owner of the farm Camelot. At the heart of this case are two mining companies, Mpilo and Zen Holdings, and Centurion Mining Company. Right in the middle of it all is the Department of Mineral and Petroleum Resources, DMPR, the regulator of mining in South Africa. The battle lines were drawn when the DMPR issued a mining permit to Mpilo and Zen Holdings to mine gold on the farm Camelot, which included the processing of the gold-bearing tailings. Centurion Mining was not happy with the decision, claiming that it owned the tailings dump, and argued that the DMPR has no authority to issue that permit. So, Centurion lodged an internal appeal with the DMPR to challenge the decision. While that appeal was still pending, the regional manager in Mpumalanga issued letters declaring that Centurion Mining was the rightful owner of the tailings and that the DMPR had no authority over dumps. This was based on a 2007 court ruling from the Free State High Court, known as the Atadikwa judgment. In this judgment, the court created a clear legal distinction between tailings dumps created before and after commencement of the Mineral and Petroleum Resources Development Act, which is the act that regulates mining in South Africa. The court found that the MPRDA regulated unsevered minerals, further holding that the tailing dump, which were the subject of the judgment, is movable property owned by the party who created them, being De Beers Consolidated Mines. As a result of the regional manager's decision, Rural Development gave Centurion access to the tailings and refused to give Mpilo access. Mpilo was thus prevented from exercising its rights under its mining permit.
Mpilo took the matter to the High Court in Mpumalanga and applied for an interdict to stop Centurion from mining the tailings until the legal questions around the DMPR and Rural Development decision is resolved. The matter came before Acting Judge Roloff, who on 26 July 2023 granted the interdict, finding that Mpilo met all the requirements for granting the interdict. The court found that the Atadikwa judgment did not create a general rule that all tailing dumps are movable property. Each case must be decided on its own merits. The definitions in the MPRDA clearly regulate the mining of tailings. Since Mpilo held a valid mining permit for gold on the property where the tailings were located, it had a prima facie right to mine them. The court rejected Centurion's ownership claim, holding that it had no current right to mine the tailings. Rural Development granted Centurion access to remove the tailings, and Centurion gave no undertaking that it would stop. If the tailings were removed, Mpilo would be permanently deprived of the opportunity to exercise its mining permit rights, establishing irreparable harm. Regional manager declaring the ownership acted beyond his legal power, and therefore the decision is not an administrative decision taken in terms of the MPRDA that could be appealed under Section 96 of the MPRDA. Thus, no internal remedy was available to Mpilo.
With the asset protected, Mpilo then launched a review application seeking to set aside the decision of DMPR, which declared Centurion the owner of the tailing and that the DMPR had no authority over tailing dumps. The core of the dispute was that these administrative actions were taken while Centurion's appeal against the granting of Mpilo's mining permit was still pending,
creating a direct conflict and preventing Mpilo from exercising its rights. Centurion opposed the application, raising a preliminary point that Mpilo's mining permit had lapsed, meaning it no longer had locus standi, the right to bring the case. The matter came before Judge Furry, who delivered the judgment on 5 May 2025. The judge strongly criticized Centurion Mining for intentionally delaying their court filings until after Mpilo's permit had expired, a move the court saw as unfair and harmful. It rejected Centurion's argument that Mpilo lacked standing, finding that it would be unjust to deny Mpilo a hearing on a technicality created by Centurion's own delays. The court further noted that Mpilo had applied for a renewal of its permit on time and it had the necessary standing to protect its interests. The court set aside the DMPR's decisions and remitted the matter back to the DMPR for reconsideration. It held that in taking the decision, the regional manager acted outside of his legal powers and it was unlawful. The subsequent decisions by the DMPR and Rural Development, granting access to Centurion, were based on this initial unlawful act and were therefore also irrational and unlawful. These actions were taken without considering all relevant facts, particularly the existence of Mpilo's mining permit and the pending appeal. The court ordered that Mpilo and Zen's mining permit remains valid until the pending appeal on the decision to issue the permit is finalized. The permit had technically expired, but Mpilo and Zen had applied for renewal on time. The court was addressing Centurion Mining's unfair legal technique it employed against Mpilo and Zen in delaying filing papers. The court gave the DMPR 4 months to finalize Centurion's internal appeal. This was a 435 million rands victory for Mpilo and Zen and a major loss for Centurion Mining. The court clarified that the Otfaka judgment doesn't create a general rule that tailings can't be mined. Each case must be judged on its own facts. The judgment gives hope to many in the mining industry who see tailing dumps as untapped opportunity. However, it creates uncertainty for holders of tailing dump outside of a mining area or not the subject of any right or permit issued by the MPRDA. It remains to be seen how the department will decide the internal appeal by Centurion Mining. We have come to the end of our video today. Thank you for joining us and hope you have learned a lot from the session together.